SLAPP lawsuits are no longer just an American legal loophole. Around the globe, oligarchs, multinational corporations, and corrupt politicians are adopting this exact legal blueprint to destroy investigative journalists, whistleblowers, and activists. From London courts to the European Union, this is the complete picture of how SLAPP suits have become a global epidemic designed to kill the truth. These are lawsuits never meant to be won. They're designed to destroy you financially, emotionally, and professionally, long before you ever see the inside of a courtroom. They're called SLAPPs, strategic lawsuits against public participation, and they represent one of the most dangerous threats to free speech happening right now in democracies around the world. The concept is brutally simple. A powerful entity, usually a corporation, sometimes a politician, occasionally an oligarch, files a lawsuit against someone who criticized them publicly. A journalist who published an investigation, an activist who organized a protest, a citizen who spoke up at a town hall meeting. The lawsuit might allege defamation or tortious interference or conspiracy. The specific legal theory almost doesn't matter, because the goal was never to win. The goal is to punish the act of speaking out by drowning the speaker in legal costs. The term itself was coined back in the 1980s by two University of Denver researchers, George Pring and Penelope Kanan. Their work revealed something disturbing. Thousands of ordinary people engaging in public debate were being hit with multi-million-dollar lawsuits simply for participating in democracy. Pring and Kanan published their findings in a 1996 book, and the name stuck. But the problem they identified has only gotten worse. Here's what makes SLAPPs so effective. Defending against even a frivolous defamation lawsuit in the United States costs between $21,000 and $55,000 at the low end. Complex cases routinely push past $100,000. For major investigations, legal bills can reach into the millions. Most individuals, most small newsrooms, most community activists simply can't afford that. They settle. They retract. They go silent. And that silence is exactly what the powerful want. Consider what happened to Shireen Seward, a journalist in central Wisconsin. She was sued for accurate reporting. She won her case eventually, but eventually cost her $180,000 in legal bills. She was named personally in the suit, and she described the experience as harrowing. Now think about what that story does to every other local journalist in Wisconsin who might consider publishing something a powerful person doesn't want published. That chilling effect spreads outward, silencing people who were never even sued. Or take John Oliver. In 2017, Colbert and Bob Murray filed a lawsuit against Oliver and HBO after a segment critical of Murray Energy. Oliver had the backing of one of the largest media companies on the planet, and he still spent over $200,000 in legal fees. His show's libel insurance tripled. Murray's company had filed at least 9 similar lawsuits against other outlets, including HuffPost and the New York Times. Oliver eventually won, the case was dismissed, and he dedicated an entire episode to SLAPP suits in response. But Oliver himself pointed out the obvious truth. Most people targeted by Murray didn't have HBO's legal budget behind them. The most devastating SLAPP story in recent memory belongs to Daphne Caruana Galizia. She was a Maltese investigative journalist who spent years exposing corruption at the highest levels of her country's government and business elite. At the time of her death, she was facing 48 active SLAPP lawsuits. 48. On October 16, 2017, she was assassinated by a car bomb. The lawsuits didn't even stop after she died. Some continued against her family. Her murder became a rallying point for press freedom advocates across Europe, and her name is now synonymous with the deadly consequences of weaponized litigation. Malta, a country with a population smaller than most mid-sized cities, has accounted for 9% of all SLAPP cases filed in European courts between 2010 and 2023. And then there's the case that may reshape the entire landscape. In 2017, Energy Transfer, the company behind the Dakota Access Pipeline, filed a $900 million lawsuit against Greenpeace, alleging the environmental group conspired to damage the company through its protest activities. Energy Transfer refiled the case in North Dakota State Court, one of only a handful of states with no anti-SLAPP protections. That choice of venue was deliberate. In March 2025, a North Dakota jury found Greenpeace liable for over $660 million, later reduced by a judge to $345 million. That judgment threatens to bankrupt Greenpeace's entire U.S. operation. In December 2024, Representative Jamie Raskin introduced the Bipartisan Free Speech Protection Act, which would create a federal procedure for courts to quickly identify and dismiss SLAPPs, prevent filers from abusing discovery to invade privacy, and allow judges to award attorney fees to victims. As Raskin put it, Goliath triumphs over David in our justice system when powerful special interests can silence their critics with frivolous strategic lawsuits. The United Kingdom took its first step in 2023 with anti-SLAPP provisions embedded in the Economic Crime and Corporate Transparency Act, which came into force in June 2025. But critics immediately noted the limitation. Those protections apply only to speech about economic crime. If you're being slapped for environmental reporting or political commentary or anything else in the public interest, the law doesn't help you. Scotland has opened its own consultation on broader protections, but progress across the UK remains slow. 166 SLAPPs were filed across Europe in 2023 alone. In Mexico, 158 journalists faced libel lawsuits between 2020 and 2025. A 2024 analysis by NYU's First Amendment Watch identified 500 anti-SLAPP motions decided on their merits in the United States in a single year. The scale of this problem is enormous, and it's growing. The tension here is real. People and organizations do have legitimate interests in protecting their reputations against actual falsehoods. Anti-SLAPP laws that are too broad could theoretically block meritorious claims. But the data overwhelmingly shows that the current system is broken in the other direction. The courtroom has become a weapon, and the people most vulnerable to that weapon are the ones democracy most depends on: the journalists, the whistleblowers, the activists, the citizens who choose to speak. Every SLAPP that succeeds in silencing someone sends a message to everyone watching. The cost of speaking truth to power might be everything you have. And in a world where that message is heard clearly enough, the powerful don't even need to file the lawsuit anymore. The threat alone is enough.